Can you actually go to jail for unpaid debt? You are sitting in your living room at midnight staring at a scary letter from a collections agency and your stomach just dropped. It says they are going to pursue legal action. It might even use the phrase civil arrest. You are panicking, imagining a police officer showing up at your job to handcuff you in front of your coworkers. I want to give you a massive breath of relief right now. In the United States, you cannot be sent to jail simply because you owe money. We did away with debtor's prison a long time ago. You will not do time just because you missed payments on your credit card, your medical bills, or your truck loan. But open a new tab right now and search the news. You will see people getting arrested over debt every single day. So what is the catch? Why do people go to jail if the debt itself is not a crime? Because they trip up and make very specific, very avoidable mistakes when dealing with the court system. When a creditor decides they want to force you to pay, they file a civil lawsuit. A civil lawsuit is just a private legal dispute where one person or company sues another person for money. It is not a criminal case. Nobody is going to read you your rights. The police are not looking for you. But the moment that lawsuit is filed, a clock starts ticking and the rules change completely. That is exactly what we are talking about today. We are looking at the specific errors people make when a debt goes to court, why those errors can literally land you behind bars, and exactly what you need to understand so you do not fall into the same trap. Remember, as we go through this, laws vary heavily depending on where you live. Every state has its own unique rules for civil courts, so you have to look at your local laws or talk to someone who knows them inside out. The first massive mistake people make is ignoring the court summons. A summons is the official piece of paper that tells you exactly who is suing you, how much they say you owe, and the deadline to respond. It might come in the mail, it might be handed to you by a process server, which is just a person whose job is to deliver legal documents. It might even be taped to your front door. When people see this paper, they get terrified and they shove it in a drawer. They think if they ignore it, it will go away. That is the absolute worst thing you can do. When you do not respond to the summons within the deadline, you automatically lose the case. In the legal world, this is called a default judgment. A default judgment is a ruling by the judge that says because you did not show up to argue your side, the creditor automatically wins everything they asked for. Once the creditor has that judgment, the game changes entirely. They no longer just have a debt on a spreadsheet. They have a court order. They can now legally garnish your wages, which means taking money directly out of your paycheck before you even see it. They can freeze your bank account. And in some states, they can put a lien on your house, which is a legal claim against your property that stops you from selling it without paying off the debt first. Ignoring that piece of paper gives them total power over your money. The second mistake is treating a judge like a bill collector. Let's say you do not ignore the summons. You actually go to court. This is great, but you have to understand what the courtroom is for. A lot of folks walk into court thinking they can explain their personal tragedy to the judge. They want to say they lost their job, or their kid got sick, or their truck broke down, and they just could not afford the payments. They want the judge to give them a break or set up a payment plan. But the judge is not a customer service representative. The judge is there to apply the law, not to manage your monthly budget. If you owe the money and you admit it, but you try to explain why you cannot pay it, the judge will still rule against you. You walked right into another judgment. The judge does not care about your hard luck story in a civil court. Their only job is to look at the contract you signed and decide if you broke it. Instead of complaining to the judge about your financial struggles, you need to be looking at the paperwork the creditor brought. Sometimes creditors buy old debts in giant bundles, and they do not have the actual proof that you owe the money. Maybe the original contract is missing. Maybe the balance they claim you owe is wrong, or the interest rate is illegal in your state. The time to fight a civil lawsuit is by attacking their evidence, not by begging for mercy from the bench. The third mistake happens when you have that default judgment against you. This is where the jailhouse doors actually start to open. Once a creditor has a judgment, they can force you to answer questions about your finances under oath. This is called a debtor's examination or a supplemental proceeding. It is basically a formal interview where you sit down and they ask you exactly what you own, where you work, and how much money you have in the bank. They want to know where your assets are so they can take them. A lot of people get the letter for this examination and they just blow it off. They figure, well, I do not have the money to pay them anyway, so what is the point of going? Here is why that is a fatal error. When a judge orders you to show up to a debtor's examination, it is a direct order from the court. If you ignore that order, you are in contempt of court. Contempt of court is when you disobey a judge's direct order or disrespect the court. And unlike your original unpaid debt, contempt of court is punishable by jail time. This is the secret backdoor to debtor's prison. You are not going to jail because you owe $10,000 to a credit card company. You are going to jail because you broke a court order. The judge will issue a body attachment, which is basically a fancy word for an arrest warrant, specifically for civil court matters. The next time you get pulled over for a broken taillight, or your name gets run for any reason, you are going to jail, and you will sit there until the court schedules a new hearing. The fourth mistake people make is lying or hiding assets during that debtor's examination. Let's say you actually show up to the examination because now you know better than to ignore it. You sit down in front of the creditor's lawyer. They ask you if you have any cash in the bank. You do have $2,000 saved up for your kids' braces, but you panic and say no. Or they ask if you own a boat, and you secretly transfer the title to your brother last week. Lying under oath is called perjury. Perjury is a felony. You are no longer in a simple civil dispute about money. You are now committing a crime right in front of a court reporter. If you get caught hiding assets, the police can get involved, and you can absolutely be charged criminally. Never ever lie to a court. It turns a bad financial situation into an actual crime. You have to tell the truth, the whole truth, and nothing but the truth. The fifth mistake is trying to fight a massive lawsuit without knowing your specific state rules. Every state has a list of rules about what creditors can and cannot take. This is called exemption law. An exemption is a legal rule that protects certain property from being taken by creditors. For example, in most states, your basic household items in your retirement accounts are totally exempt. Creditors cannot touch your 401k, but the rules vary wildly. In some states, they can clean out your checking account down to zero. In other states, they have to leave you with a minimum balance. Some states can garnish your wages, while other states do not allow wage garnishment for credit cards at all. If you do not know what is protected in your specific area, you might voluntarily hand over money or property that the creditor legally was not allowed to take. This is exactly where you need to stop playing guessing games. You need to talk to a consumer protection attorney. A consumer protection attorney is a lawyer who specializes in fighting for everyday people against banks, debt collectors, and credit bureaus. A lot of people think they cannot afford a lawyer when they are already drowning in debt. But many of these attorneys offer free consultations, and a lot of them will only charge you if they win your case, because they can force the creditor to pay their legal fees. Even if you only have a consultation, you need to know exactly how the exemption laws work in your backyard. You need a professional to tell you what the local judges expect and what the local creditors can legally grab. The final mistake is letting the fear of the judgment paralyze you completely. A judgment is not the end of the world. It is just a piece of paper that says you owe money. In many states, judgments expire if the creditor does not actively collect on them within a certain time frame. If you are facing a massive lawsuit, there are legal tools designed to give you a fresh start. Bankruptcy is a legal process that wipes out your debts or reorganizes them, and it immediately stops all civil lawsuits and wage garnishments dead in their tracks. It is a massive legal hammer that stops creditors instantly. The moment you file for bankruptcy, the court issues an automatic stay. An automatic stay is a powerful court order that tells every single one of your creditors to drop everything and back off. No more phone calls, no more lawsuits, no more frozen bank accounts. If you are in over your head, you need to ask a lawyer if bankruptcy makes sense for your specific situation. There is no shame in using the law to protect your family. Look, the collections industry is built entirely on fear and intimidation. They send you letters stamped with urgent legal warnings because they want you to panic. They want you to make these exact mistakes. They want you to ignore the summons, skip the debtor's examination, and give them a free pass to your paycheck. If you understand the rules of the game, you take their power away. You show up. You read the paperwork, you file your responses, you tell the absolute truth, and you demand they prove you actually owe the money. You cannot go to jail for being broke. You only go to jail when you let fear dictate your actions and break the rules of the civil court system. Have you ever received a scary letter or phone call from a debt collector that sounded more like a criminal threat? Tell me about it down in the comments. If this breakdown helped clear up some of that middle-of-the-night anxiety, pass it along to a friend who might be ignoring their mail right now. And make sure you subscribe so you have a blueprint the next time the legal system tries to back you into a corner.